Hello, everyone. Welcome to another Talking Feds one-on-one. So, with each report of the exorbitant fees that Donald Trump has spent on lawyers, upwards of $70 million in the last couple years, reports go out of, but he can just, pay for this with contributions and just sort of ask or bilk his supporters into funding those bills. And that in turn, raises the question, really? And what are the legal restrictions on that? What's fair and what is foul? And it's a very complicated area. I think there are a few clear lines and then some fuzzy lines as well. And so we're lucky today to have one of the perfect people in the country to explain it to us. Adav Noti is the executive director of the Campaign Legal Center. He oversees the center's efforts to fix the campaign finance system, among many other things. And he previously had a career and a number of important roles in the Office of General Counsel for the Federal Election Commission. So very pleased he could join us to try to get through this somewhat murky area. Dove, thanks so much for joining.
Thanks for having me.
Okay, so let's start with the clear lines. There is a pretty obvious fair and foul territory. Yes, I mean I take it that just as they pay for office space and billboards and the like, campaigns can sometimes pay for lawyers. You need them sometimes, fact of life. And then there must be situations where, they can't pay the divorce fees of the candidate. What is clear out there, and then we can start to bore down a little on the points that may be less clear that Trump is trying to exploit.
Right. And so there are a few different pots of money really that we're talking about here, or potential pots of money. And I think the one where the rules are the clearest is when we talk about the campaign account, right? So money that's in like the Trump for President campaign account. And the rules there are clear. And it's that money in a campaign account cannot be used for the personal use of the candidate or anybody else, but in this case, the question relates to the candidate. So money in a campaign account can't be converted to the personal use of the candidate. And the way that that is determined, whether something is a personal use or not, is whether that expense that's being paid for would have existed anyway, even if the person weren't a candidate. So if it's an expense that they only have because they're running for office, or they're holding federal office, that can be paid for with campaign funds. But if it's something that they would have to pay anyway, even if they weren't a federal candidate or office holder, that is then a personal use and cannot be paid with campaign money. And that is a rule that's been in place for many years and been enforced in many situations against
All right, and
candidates.
so that hasn't created sort of difficult borderline questions, well, let's say. All right. And that is, you write a check, Donald Trump for president, literally his campaign. So what's the next entity?
So the next entity is it's sometimes just called a PAC, but
Hmm.
in technical legal terms, it's a leadership PAC. And this is a sort of a separate pot of money that people who are running for federal office or who hold federal office are allowed to collect donations into and spend. And what it's supposed to be for really is for them to support the campaigns of other people. It's supposed to be a way for members of Congress to support other members of Congress or people who are running for Congress. That's really what it's for. In practice, the rules around these accounts are very lax. There are restrictions on how much anybody can give to a leadership PAC, but what the rules for what happens with the money once it's in that account are quite few and far between.
And now we are getting to the heart of the matter, because I guess his Save America PAC has dispensed something like 85% of all of the millions and millions of dollars. You say it's pretty straightforward, just the getting into before how you spend, but is it, if you're just a regular citizen and Trump says they're coming after me, and please make a contribution to, respond to the Biden campaign's legal, criminal act charging and the like. Do you know, is it fairly transparent to you whether you're giving to Donald Trump for president or the Save America PAC? And how can you know?
Right. So the law requires a candidate who's soliciting in that sort of situation to say in the solicitation where the money is going to go. As a practical matter, what the Trump campaign has done for many years now, this goes back to before 2020, has put that information pretty buried in most of the solicitations, usually down the bottom in small font. And what it usually discloses, that the allocation formula has changed over time, but what it usually discloses is that some portion of that money is going to the campaign, and some of it is going to this other PAC, this leadership PAC, which does not have the same restrictions on personal use. And therefore, that money that goes into that other PAC can be used to pay personal legal expenses.
And I'll get to that, but just a quick question. If you have that dual use, I assume the rules for the PACs, the leadership PACs, and not the rules for the campaign is what apply. I give to an entity that says it'll do both. I have to comply with the disclosure and other rules, such as they are. We'll get to that in a second for leadership PACs. Yeah.
Right. And what the way that the disclosure and the allocation usually work is it'll say something like 90% of your contribution will go to the campaign,
Uh-huh.
10% will go to leadership. Backer, it'll say the first $2,000 that you give goes to the campaign. Anything above that will go to the leadership PAC. That's usually the way the allocation works. And then the money is split up on the back end.
All right, well, let's put it in practical terms, though. Donald Trump just goes on, TV or at his rallies and says they're coming after me, or he seems to do this with every adverse decision. I mean, it follows immediately some kind of fundraising appeal. So I hear that appeal. I sympathize with his stance that they're coming after him, and I want to give him $20. I haven't reached that point yet personally, but if somebody reaches it and they're ready, they want to send a check for $20. What's going to happen such that before the PAC actually, deposits that check, that person's going to be told ostensibly what that money's for?
Right. Well, the vast majority of $20 donations or donations in that range that are coming in are not coming in by check. They're coming in
Right.
online. And so you have in order to make the contribution, you have to go through a donation page that spells out the allocation formula. If somebody does send in a check, and that it happens sometimes.
Well, no, I meant the don't
Yeah.
this way too. Yeah, but so the
Right.
page would have it, and needless to say, as you've probably in practice found that people don't pay much attention to that, and I guess there's no legal requirement that it be knowing and intelligent or that sort of thing.
Right. It's not a waiver or
Right.
construed like that. It's just informing the donor where their money is going to go.
All right.
It also has to be tracked because those different pots of money have different contribution limits. So both the recipient entity and the donor have to keep track of whether they're getting close to the limit for that entity.
And what for that entity or for that? Okay, so just for that entity, I can give to pack after pack, but each individual one, there's a ceiling of about how much?
It's usually $5,000.
Right.
There used to be a total cap on how much you give to all PACs combined. The Supreme Court, in one of its early campaign finance cases in the Roberts era, struck down that limit. And so now, yes, the average donor who has a few $1,000,000 to spend can distribute it in $5,000 increments to unlimited numbers of PACs.
All right. So I want to bear down here, but just let me make sure the original taxonomy we talked about the limitations and restrictions if it's a check to Donald Trump for president. We talked about it if it's a PAC or leadership PAC. Is there, for practical purposes, another kind of contribution to another entity that's a big factor in this overall area, excuse me, of whether Trump can pay his legal fees with contributions?
So the other pot of money that's out there that comes up sometimes is the super PAC, right? These independent entities that are independently and with no coordination, supposedly, with the candidate supporting their candidacy. And like most federal candidates now, the Trump campaign has supportive super PACs out there. Super PAC, there is no sort of rule on the books that says a super PAC cannot pay personal expenses of a candidate. But as a practical matter, they really can't, because the one main rule for super PACs is that they can't coordinate any of their activity or spending with a candidate. And it's awfully hard to see how they could pay off the personal
Yeah.
expenses of a candidate without coordinating that with the candidate.
All right. So the action here is all at this leadership pack level. Yeah.
Yes.
All right. So now money comes in, and it does seem like we've established one problem for starters, which is you can be wanting to support Trump in some, and what I'll stipulate any candidate, but I think in practical terms, it comes up with Trump now, especially given his outsized legal expenses. You can want to support in a general way and not thinking that your money is going to pay Alina Habba or whatever. And nevertheless, you wind up making a contribution. We see how that can happen. You don't read the fine print at the end before you push the button and give the $20. Okay, so that's one kind of possible weak point in the system. But now the money has found its way in. And now the question is what's fair, what's foul, and what's, borderline for the activities of a leadership PAC as far as paying a candidate's legal fees. Or I guess theoretically, it would be the same if you're paying the chief of staff legal fees or the person that the candidate wants to keep close to and not rat on him legal fees. I assume the same analysis. Yeah.
Right. So when it comes to the money that's in the leadership PAC, the rules are pretty murky. If you were just to look at the law that as it's written, it seems to say that leadership PAC money can't be used for personal reasons either. But over the years, the Federal Election Commission has sort of gone back and forth on how it's interpreted and applied that law. And right now, the position that the FEC has taken, and this is the agency that's in charge with answering these questions and enforcing these rules, the position that they've taken is that leadership PAC money is not subject to the prohibition on personal use, meaning that money that's in a leadership PAC can be used for the personal use of the candidate. Now, there may be other laws that restrict that ability. There may be tax law implications and other implications. But for purposes of campaign finance law, as far as the FEC is concerned, there is no restriction on using PAC money for personal purposes.
Wow. So now that is huge. And for that matter, I guess there are disclosure issues. And I think in general, it's a robust disclosure scheme and you can run afoul of those. But so that would include, unless there are other laws broken, say paying hush money to a porn star, whatever. There's literally personal use is personal use. The candidate wants to go on safari. There's nothing that says the candidate can't do that with the leadership PAC money.
Right, and the real life examples that have happened and continue to happen pretty regularly involve trips to Disney, involve trips to Europe. Yes, the abuse of leadership PAC funds to finance what are pretty obviously personal uses of federal office holders and candidates is a significant problem.
Well,
The
let me.
FE
I mean, you call that abuse. It sounds like the FEC has done something bizarre and maybe derelict, but there's no abuse. You would. I mean, is there Adav, a kind of new legal nuance here that, like in practice, you can do personal use, or literally the interpretation of the FEC is that money that comes into a leadership PAC can be employed for the personal use of the candidate, full stop. That's the law as the FEC hears it.
That is the law as the FEC is currently interpreting it. Yes, that there is no prohibition in campaign finance law on the personal use of leadership PAC money.
Well, let me take the next step. You have, say, an $83.3 million judgment against you for defamation, and you conveniently have that much in your coffers, personal as can be. No problem. As far as the FEC is concerned, and election law for leadership PACs.
Right. The FEC would not take any enforcement action against that use. And now the FEC, to be clear, doesn't enforce very much anyway, even when the
Yeah.
rules are clear. But in this case, particularly in recent years, the agency has been fairly consistent in saying that it is not going to apply the personal use rules to leadership PACs.
Yeah, and it's not going to not take action because of prosecutorial discretion or whatever. It's just there's no problem as far as the FEC is concerned. Well, okay. So first of all, and I think the viewers would feel the same. Now we're at the heart of what seems to be the problem. Now I sort of see it. Second, it's a little. I hadn't appreciated it till this talk. So thanks again for being here. But it's gobsmacking. There's no what has generally been assessed, in soundbite ways on TV. Well, there are rules, blah blah. It is the total Wild West for use of leadership PAC funds. Anything goes.
Yes, unless there's some other law that restricts the ability. But
But
campaign,
not an election. I'm just saying as far as election laws go. All right. So I guess all that's left, the only shred of accountability then would seem to be disclosure laws. And so let's just talk about those for a second. If I go to Disney or pay off a porn star, are there rules about leisure travel? And is that enough? Or payment to consultant, payment to consultant for reproductive services, whatever. Can those be hidden effectively, or at a minimum, is there a disclosure regime so at least the voters have a sense of what the candidate is doing with the leadership PAC money?
yeah, so in theory, every dollar in and every dollar out is supposed to be publicly disclosed, and all that information is posted. As a practical matter, the disclosure on the incoming side is very good. Where you really can basically figure out where all the money in a given PAC came from. The disclosure on the outgoing side, where the PAC is spending it, that disclosure regime is not so good, and it is relatively easy to list certain disbursements as being for consulting or
Right.
Other things that are pretty generalized. In prior years, at least there was some certainty about who was getting the money, right? Even if the purpose was vague, the recipient would be clear. It would say, the money was dispersed to such and such a person. But even that has been undermined pretty significantly. And the Trump and Clinton campaigns were sort of the pioneers of this. And they both figured out a tactic, which was if they dispersed their money through intermediaries, right? If they pay it to some company that then disperses it further, all the campaign discloses is that it paid the intermediary.
Right.
And the public doesn't find out where that money is going.
Acme. Yeah.
Right.
All right. Well, look, I really appreciate and try to emulate, in fact, your sober analytical style, but this is a fucking scandal. No, I mean, so this is crazier than and I think most, even relatively conversant observers understood.
Yeah, it's a scandal, and like so many things in election law, the scandal is not necessarily violations of law. The scandal is
Right.
what's legal right now.
Right.
And I think there is not widespread understanding that most members of Congress have pots of money that they raise and then can spend on themselves. and many of them do. I don't think there's widespread understanding of that, and I think there would be more of an outcry for reform if folks understood that that's what's happening.
All right, and the secret golden ticket here is the so-called leadership pack. So let me just get back to that point. Is it hard to form? Are there any kinds of impediments or hurdles at the level of formation, or you just sort of set it up, and then as long as with small print disclosures, people can be persuaded to contribute to it. It's Katie bar the door.
Yeah, there's the only real constraint is the limit on the amount that any one person can contribute. So,
And 5,000 is a lot of money. Yeah.
right, it's far more than the vast majority of Americans will ever give to a candidate. So what in practice happens is that the folks who are giving to these PACs, they're not being hoodwinked into financing
Right.
the personal expenses of the candidates. They know very well that's what they're doing, and they're doing it to buy access to those candidates and gratitude from those candidates, so that they can say either explicitly or with a wink and a nod, I hope you had a nice vacation on my dime. Can we
Right.
talk about this law I want passed? And that's the way it actually plays out.
Okay, so is the Campaign Legal Center or others? I mean, this really seems quite a flaw in the whole heart of the fabric here. Are there efforts to change it?
Yes, very much so. Campaign Legal Center, we've tried to encourage the FEC to change its own interpretation of the law, which it could do. The way that that agency works, though, it is run by 6 people. They are, by law, have to be sort of 3 of one party and 3 of
Right.
another, and it's very, very difficult for them to agree on anything, much less on strengthening laws. They tend to reach agreement on
Yeah.
weakening laws, not so much strengthening them. So that would be one avenue. It's not going to happen right now, given who's currently running the FEC, but maybe in the future. The other avenue, of course, is Congress could do something about this. And you could say cynically, well, why would members of Congress want to fix this? They benefit from it. That is true to some extent, but there are many members of Congress who have said, both publicly and privately, this is a real scandal. This is not what we're
Yeah.
supposed to be doing. And it looks bad. And for the, you know, 50% or more of members of Congress who do not misuse their leadership PAC money, who actually spend it on what they're supposed to spend it for and not on vacations, they really don't appreciate being tainted by what their colleagues do.
And
So,
and
and
I'm
it,
sure it puts them certain at a disadvantage for people who could, yeah, and of course it can be used for campaign stuff that could be, yeah, I can imagine why a just ordinary old member of Congress would want to change this. And you say you keep coming back, and it certainly dovetails with my instinct, what they should be using it for. And yet, the legal landscape as you've defined it doesn't accord with that. I assume, is there some kind of, and we don't have to go to a deep dive on it, but there's some like Orwellian legal interpretation going on here where the law says you can't use it for personal use, but there's an FEC regulation that says, oh, by not personal use, we mean anything goes. There's some kind of weird regulatory maneuver at the core of this.
yeah, it's actually not on the definition of personal use. The weird maneuver that the Federal Election Commission has pulled off to legalize this sort of personal spending is that they've narrowed the application of the ban from what it actually says in the law, which is any money received by a candidate or office holder, to apply only to money received by a candidate or office holder and deposited in their campaign account. And that and
I
and the
see.
FEC has imposed that limitation without any clear legal authority, but that is the current
And
interpretation.
maybe that very bright idea came from particular members of Congress or lobbying groups. Yeah, where it's an old ugly story. By the way, do you see anything in the Supreme Court's agenda to kind of disempower agencies and not honor their quote unquote reasonable interpretations that would have purchased here? Is there a chance that the court changes the kind of entitlement of the FEC to make Orwellian regulations like this?
Yeah, I think some of the debates about courts and deference to
Yeah,
agency actions, folks have differing views about how that plays out in some regulatory circumstances. But I think for when we're talking about election law and campaign finance law and the FEC, there would be some benefits to paring back some of the deference that agencies get,
yeah,
because the way the law has developed around the FEC is that generally the FEC does not act. It fails to act, and in a sort of strange and I think unique arrangement that applies to no other agency in the federal government, that those failures to act get deference from the courts. So courts defer to the inaction of the FEC, which is very, very unusual and is highly problematic, because all of those inactions, almost by definition, are loosening of the rules or refusing to enforce the rules. And so it's a one-way ratchet towards, opening up the floodgates for money and influence in elections. So if there were less deference to agencies generally, in the context of the FEC specifically, that might not be the worst thing in the world.
got it. All right, everyone, you've heard it here. It seems rapacious and sleazy and aggressive and Trumpian as can be. Illegal, however, it seems not to be. And if that's a matter of consternation for you, as it is for me, you can at least locate the source of this broad, almost unlimited license in a interpretation of rules by the FEC. So the administrative state, it gives and it taketh away, and it's a big part of our life, and even in ways we don't know. Adav, thank you so much for being here to explain it. It turns out to be simpler and more pernicious than I'd understood. And so we'll have to we can continue to sit and watch as Trump pays anything off from a leadership PAC, but sleeping comfortably knowing he's complying with what the FEC says the laws should be. Thanks very much for the sobering but very illuminating explanation.
Great, thanks for having me.
Hi everyone, Harry here with a really exciting announcement. Talking Feds is bringing our lively discussions with prominent national figures live to San Diego. Talking San Diego is a new series of conversations with some of the country's most interesting and bright minds from the worlds of politics, public policy, law, and more. Our first event is just around the corner. Join me for a conversation with Congressman Jamie Raskin on Monday, March 18th at 2 o'clock in downtown San Diego. You can click the description box below for more information on the event and the series and find out how to purchase tickets, which are going fast. I can't wait to have some of our most well-known friends of the podcast join me in person before a live audience. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.